Welcome, everybody. Thank you, everyone, for coming, and thank you, Anne, for setting this up. My goal for this is that it really is a discussion. The topic is civility generally, and I have a particular interest in it. My observation is civility historically with the Bar Association, Contra Costa Bar Association, has been really strong and collaborative. And over the course of, I don't know, past 5 years or so, that's been shifting. I think it's been shifting societally overall, that things have become less civil, and our Bar Association and the families we serve doing conservatorships are no different. So I was hoping that we could talk about that in a frank sense and hopefully come up with some ideas about moving forward. So as Anne said, I've been practicing in this county for 22 years. About, I'd say 14 of that has been doing probate, trust, elder law, conservatorships. I do a little bit in other counties, but for the most part, it's Contra Costa. What I like about conservatorship practice as opposed to the civil work that I had done before was it's actually real life and real people, and we actually help people with their real problems. And I'm something of a gratitude junkie, and it actually feels like people are appreciative of the work that we do. But the bad side, the downside of it is it's very stressful work. You're seeing people at their worst, dealing with death and dying and losing the core of their family, and they're fighting about money. So it can be a very dark and stressful practice area compared to when it's just about contracts and money. It's bigger issues than that. What I like about the Contra Costa Bar, and particularly the probate bar, is that, like I said at the beginning, it's a very collegial group. Historically, it's been the kind of group of people that you can call and ask opinions and get advice and instruction. And that's how I learned the ropes, is learning it from people who have done it for years before me. And that happens still now. I'm not sure that it happens as much, but that's part of what I think has really made this practice area enjoyable for me, is the community of practitioners. And we're also, I think, a pretty pragmatic group of people that we try to find solutions for our clients in a way that really does help them without draining the bank accounts. Although that's one of the things that I think is a struggle in this practice area as well. What worries me, I think civil litigation has kind of infiltrated into the probate bar a little bit more than it has historically. And I see it with discovery practices and motion work and just how people address the problems. And that would be one of my questions to toss out to you all. Is that other people's experience as well? Matt, do you have any sense of that?
Yes. There's certain attorneys that, like to get the case resolved and let's do it the most efficient way possible. And then you run into those attorneys that how much money can they possibly make and how much can they cost the other side versus what's best for the elder.
Yeah.
For example, some people like to send out form interrogatories, which have no place in a conservatorship case at all.
Right. I see what I see is people leap into those types of tactics, and discovery can be appropriate. If you've got a financial elder abuse case, that can be appropriate. In conservatorships, it doesn't make any sense at all. But they do have their purposes. But it seems like people leap to that before they try some kinder and gentler solutions. And one of the other things that I really like about the conservatorship practice is there's a North Star that everybody who's involved with it should be focused on, which is what's in the best interest of the elder. And I think that's always been something that has tied this practice area together and the practitioners have in common. And that part seems to have been lost. So that's one of the things I want to get back to. And I would like a sense of whether other people see that as something that's important that we get to. In part, I think it's because the families are, there's more people struggling just from a demographic standpoint, and people are more desperate. The way people interact with each other is a little rougher, a lot rougher. So at the end of this, I really want to talk about what do we do about it. I went back in the handouts, you'll see, and I can throw them up also on the screen, but I went back and actually looked at the local rules, the bar association, the state bar, to see what is the standard of practice. As it turns out, many, many moons ago, the bar association established practice standards, professionalism standards. And it had a whole list of things that we all agreed on, apparently. And this was back in the late 90s. And we agreed on them so much that the local rules for Contra Costa, the court adopted them as part of the local rules. It's not specific to conservatorships or probate, but I thought it was really interesting that we cared, once upon a time, we cared so much that we actually agreed upon a set of standards. So that's in your packet, but I wanted to just quickly go over some of them. They make it really clear that we in Contra Costa hold ourselves to an even higher standard than what is expected of the people in the state bar generally. It includes advance notice of scheduling for any activities that are in the litigation, avoid continuances and delays that aren't necessary, be very mindful of how you give notice and you serve people so as not to take advantage. Discovery, and that includes how you propound them, how you respond, meeting and conferring. You're supposed to set yourself up to a high standard in not wasting people's time and using it as a tool in and of itself to get some sort of advantage. You should be very careful in how you deal with conflicts with counsel and other parties. Demeanor is very important. How you represent yourself to the court. You are supposed to be accurate in what you state to the court, and you are supposed to avoid any unnecessary actions or illegitimate objections. Now, I'm reading through this list and I see it as something that has expanded over time and has more of a role in how we end up dealing with conservatorship cases. And show of hands if that's something that you've seen too. I think it's a pretty common experience. And I find it heartening that at least once upon a time, we cared enough to actually put it into the local rules. The state bar, by the way, has similar rules. They don't go into near as much detail as our local rules do. Our local rules are pretty spectacular in how detailed they are. One of the reasons, so I have a list of things also that I think are what makes conservatorships different, and why the civility really matters all the more. One is we're dealing with the families in stress situations, high stress, and they're frequently really dysfunctional families by the time they get to court, but not always. And so one of the things that I see impacting that is you end up with families that have never been in court. There's not money for being in court. These are often small estates, and with a conservatorship, it's the last, it's the last option. You know, it's the nuclear option, or someone needs the conservatorship because there's a capacity issue, they actually need it. It's not like it's a choice to be in court. They need it in order to get care for their family member or to save them from a situation that can be dangerous. So you have lots of pro pers. You have people who socioeconomically and culturally have no experience with court. They can't afford it. It's stressing them out. And then here we are as attorneys who are taking them on and shepherding these cases through. You've got court-appointed counsel, you've got probate examiners, court investigators. there's not a plaintiff and defendant, and people think of it as court, so there must be plaintiffs and defendants. There's a good guy and a bad guy. But conservatorships aren't set up that way, and people don't understand that who aren't used to the system, even other attorneys who don't do this as a practice area. And then the subject matter being about capacity and placement and what's in the best interest and can they handle money? And then you've got private fiduciaries on top of it. All of these things make it all the more essential, in my view, that the attorneys have a grasp on how to deal with each other and how to deal with families that are in crisis. And there's a whole spectrum of skill sets that people have. And so what I want to address, without naming names, which is hard, is how do we as a bar get back to that standard so we can help these families and not have it all be about fee petitions and ultimately, this is where the rubber hits the road for me. These conservatees, the elderly folks, are the ones who end up paying for all of our fees. And you talk about what's in the best interest of the conservatee, it is never that they end up paying hundreds of thousands of dollars in attorney's fees for something they never asked for to begin with. And I don't know, me sitting here as just one attorney, what to do about that. But I do know in private conversations that I've had with people that it is something that other attorneys care about an awful lot. And there hasn't really been a forum to talk about it. So at the end of all of this, what I'm getting at is I want to start the conversation, and I hope other people want to start the conversation too. So I see that there's a list of people who have been practicing in this area as long or longer than me, and I really do want to make it a conversation with all of you. So here's a general question that I want to just toss. What is our job as am I right that it's really to advocate for what's in the best interest of the elder, regardless of who it is that you represent? Do we have agreement on that fundamental concept there?
Yes, at least for me.
Is there anybody who sees it a different way?
So, hi. I personally see it that way, but I don't think that's how we're supposed to do it. I mean, I think it is supposed to be you're advocating for what the client says they want. And I know that like Andy Verrier and some other people who are very involved in lawmaking and policy writing have very strong opinions about why this is so. But basically, the argument goes that you are to be the voice of the conservatee. You are not the court investigator who writes a lengthy report about what they observe and what's best and what's not best. And you're not the guardian ad litem who is serving to render an opinion that the conservatee cannot themselves express. I don't practice that way. I try to strike a middle ground. I do a lot of like winking to the judge when I am representing a conservatee or a child for that matter who doesn't want what is clearly in their best interest. But I do think that the law, that our role is really supposed to advocate. So I feel like I'm constantly walking a tightrope, and I get very frustrated with other attorneys who will only advocate for what the conservatee wants, because I think that's a major disservice. And I think it causes protracted and expensive litigation when you do that.
So do you think it's different, like because the dynamic is, as a court appointed, you're getting paid by the county. Unless there's an estate, ultimately you get paid out of the estate. Do you think the problem then stems from people specifically in that role getting more litigious because their income is secured in a sense? It may be less if you're getting paid by the county, but is that a motivator for people, you think, in that role? Because I see it as more people who are advocating for a family member who ratchet up the fees. And I'm always confused by why people assume that they're entitled to fees from the conservatee. I totally get what you're saying, by the way, because that's a huge ethics issue. Are you a reporter, or are you a reporter of what's in the person's best interest, or a advocate? And how do you do both when your client doesn't want to do something that's in their own best interest?
Well, I think you have to divide it into two separate hats. One, are you private counsel representing a petitioning party, or are you court-appointed counsel for this person with dementia that doesn't know what's going on? Two different roles.
Yeah, and I see, to me, most of the mischief happens when it's in the former, that you're representing the petitioner rather than the conservatee. But I don't know. And does it really make a difference from the ethics standpoint that I'm coming from, of what's in the spending the money on litigation and the stress, by the way? I mean, litigation can literally kill people when they're 90 and dragged into court. So do people, let's continue the conversation. So is the job different if you represent a family member and petitioner, and how much advocacy you're supposed to do when your client is perhaps advocating more for their own interest than for the interest of the conservatee?
I think that's a hard question, because it's this whole area of law is so people driven, and we're dealing with people, we're dealing with emotions. I don't think you can have one blueprint for each conservatorship case you do. It's going to be constantly changing for the personalities that you're dealing with.
So
I mean, I kind of feel like our duty, if we're representing the petitioner, is for zealous advocacy for the petitioner, and that really we're not supposed to be focused on the best interest of the conservatee. We are focused on the best interest of our client. That being said, I think we need to temper that with being realistic and ethical. But I do think that there's, everybody does their job, right? Just like in criminal defense. We are pushing forward the narrative and the perspective of our individual clients, and then there's always someone pushing back.
To me, the classic scenario is you represent the kid who's still living in home with mom and dad and have been living off them and don't have their own ability to support themselves. Somehow they found their way to your office. And so then to me, the ethical dilemma is knowing that the only way you get paid is through the conservatee. Do you take that case to begin with?
I personally don't.
I don't either. Do you think, my assumption is there are people who will in our county, and that's a profound ethics issue to me. I don't know if it's our job to police that, though. And I don't even know how we would.
I mean, I have a different perspective. I think sometimes the family dynamic is such that there's a an adult baby who lives in the house who may actually be in the right. Like they may be the child who had a failure to launch. Actually, my partner and I talk about this a lot. You've got a child with a failure to launch who's always been the homebody, who stayed with mom and dad, and now mom and dad are demented, and maybe the vultures are circling, and it's not the adult baby who's the problem, but it's like another sibling or a girlfriend or a caregiver or whatever. And so I think you have to take it in each individual case, but I don't think it's ethically inappropriate to spend the conservatee's money on seeking a conservatorship, even if it benefits the failure to launch child, and
How about-
even if you're getting paid.
How about
would do it.
objecting to the petition if you're the failure to launch child, who's the caregiver and thinks that they can do it all just fine? It's always been this way. So there's no need for a conservatorship. Does that change the ethics to you?
I mean, Kathy, you and I had a case like that, where the daughter of the conservatee had been a very poor caregiver for a very long time, and her attorney was getting paid out of the trust and out of the conservatee's estate, and those fees were astronomical, and it was very frustrating. But on the other hand, I mean, I think it's your duty as an attorney, and this is something that Joe Morrell would say all the time. It's like, I will represent the person who's been stealing from grandma forever, but I'm not going to help them keep stealing. I'm going to help them put back the money or stop the bleeding. And I do think that you can represent these questionable people and do your best to try to rein them in. And you can always let them go as a client, but I don't think it's an absolute rule that you don't advocate somewhat for the bad guy. Because honestly, it's hard to even know.
I agree with that. When they come in the door, you don't know if you've got the good guy or the bad guy.
Yeah. And you begin to form an alliance with your client, right? Like you kind of buy into it. And sometimes it takes a while to snap out of it, at least for me.
Well, and then the other angle of it too is, what would the elder want? What would the conservatee want? If they have a failure to launch kid who they've been helping all this time, they probably would want to continue to help them to the best of their ability. But you have to temper that with, there may not be money to do that, and their care has to come first. So these are all ethics issue and how you manage the case. And frankly, there's often not a good guy and a bad guy at all. There's just different views of the same beast. So then how does that dynamic, when getting back to your initial point, where the conservatee may not want what's in their own best interest, what's the duty of the team? I often see the attorneys as a team, right? Everyone's coming at a different vantage point. Hopefully we're going to help the dynamic, not hurt it, and because we've got people already in crisis, already fighting. So how do we get them all to the table to a solution that is going to serve the conservatee best? And that's where I see it break down with certain styles of advocacy and when the civil litigation comes into play. And I think that has changed, and I'm kind of thinking this through as I'm saying it. So mediation, I think what people do is they wait to get to mediation before they have conversations with people. And mediation is great and all, totally love it, and it's great, but people end up entrenching and doing the discovery and pissing people off. And then people have gotten their positions, it's gotten expensive, it's a year later and we're still here having continuance after continuance after continuance. How do we stop that? How do we make it so that civil litigation influence doesn't poison the opportunity to actually come up with what I think of as a family plan? Have people had success with that? Doing it earlier? You're shaking your head, Laura.
If you've got an intense civil litigator on one side who's propounding discovery and refusing to mediate early, there's very little you can do. And I do think that it's helpful early on to get a 730 expert more often than we do it. I think that helps drive the settlement process. And I think sometimes we wait a long time because it's expensive, but I feel like that should be one of the first things that any petitioner, or even, even the attorney for the Conservatee. And I've been working hard with Bill Green and the conflicts committee to try to get it so that conservatees who have little to no estate, when we're getting paid from the county, we should be able to pay for a 730 expert. We should be able to use, because criminal defense attorneys get experts, and I feel like we should be able to get reimbursement from the county, and we aren't trying enough, but we can. If we ask, we can usually get it. So if you're representing a conservatee who has a small estate, you can seek payment from conflicts.
That's a really great idea. I hadn't thought about that.
It'd be a good tool to have as court-appointed counsel.
Yeah, well, and that's the appropriate source for it to come from too, instead of it being part of the adversarial back and forth. I mean, what makes me question too about sharing medical records, there's HIPAA concerns, and there's parts of the file that are confidential. But I'm a believer in more information is better to share, and that usually helps diffuse things. And I suppose that would be the argument in favor of discovery, but how would we figure that part out of sharing information in a way that doesn't require discovery, that can move a conversation to creating the family plan in my mind? Do people share those medical records voluntarily? I don't think you can.
Well, like when I'm court-appointed counsel, whoever subpoenas the records, I just ask them to send me a copy of them, and they usually do.
Yeah, that's what it gets to the point of subpoenaing, because that's incurring a cost right there. Yeah, but that would be the way to share it for sure, officially. Any other ideas about earlier interventions, not just for the medical part, but financial too?
I mean, it all depends on who's on the other side of the fence. Because, for example, I had this one case, everyone knew where it was going. Laura started it. She knows which one I'm talking about, but the fees were $100,000 to 3 different attorneys. And it just did not need to go there at all. It should have been a one and done case, meaning one court appearance, done. But we get, a mixture of attorneys, and it just costs the conservatee a ton of money needlessly.
There has to be some sort of community solution to that. Because those attorneys still get work somehow. Even though I can't imagine that a client who has to pay out of pocket for that is happy about that. And it doesn't serve anybody well, especially the conservatee. So Matt, do you have a sense from sitting pro tem how the courts view that? Does it come across to them?
It does. I've never sat down and had a conversation with the judge, but I've talked to various court personnel, and I'm not going to disclose their thoughts, but I know the judge's thoughts, mostly Judge Sugiyama's thoughts. I know his thoughts on certain things and certain people, and I'll leave it at that.
And one of the things that I've heard people grouse about a lot is that fee petitions get granted very liberally. And I think that that's a judgment call, but I think that's still the case. And if that got shut down a little bit more, but I don't know. I don't know the solution to that either. here we are on the bar side of things. And I'm sure it's a lot more complicated on the judge side of things of how you make those calls. What are people's experiences in other counties compared to Contra Costa though on that? Because I can tell you my experience is fee petitions get scrutinized painfully in other counties in a way that don't here.
Yeah, Alameda really scrutinizes, and if you represent the bad guy, you're not going to get your fees, which is a policy that, I mean, it's very hard to get your fees if you have the bad guy. Even if you help the bad guy stop, you won't get paid out of the Conservatives estate. And I think Solano similarly looks through everything with a fine tooth comb. I do think that there's a movement within Contra Costa. I've talked to Scott Thomas and Rose Parson about this. They are definitely taking a more critical look at private professional fiduciaries bills, and those can be very, very high. And they routinely get approved. I feel like Contra Costa gives a lot of deference, where maybe they shouldn't. You know, Cara knows this.
Cara, that's a toss off to you.
Well, I was just going to say, I agree. The other counties that I appear, the fees are scrutinized. And I'll tell you, one of the cases that got away in my world, Contra Costa granted a temporary. And even though there ended up being no supporting capacity declaration, and even the 730 expert said there shouldn't be a conservatorship, the temporary remained in place. That allowed the petitioning attorney to go wild on fees, and we couldn't settle the matter. We couldn't settle the matter without paying off some of those fees. And I think, you know, that was just a terrible outcome for everyone involved. You had a conservatee who shouldn't have been conserved, and she had to pay attorney fees for an unwanted conservatorship matter. And I'll tell you, I petitioned for temporary in Alameda recently, and boy, was it scrutinized. But I'll tell you, I appreciated it. I appreciated the notice required. I appreciated that the court investigator had to weigh in. And so I'll tell you, I don't like how quickly Contra Costa is to grant a temporary. I would like to be able to have some sort of third party, whether it's a court investigator or some additional notice, as opposed to just walking in, having the court sign it that day. And then you're already in this position where you're having to fight to get rid of an unwanted conservatorship. And meanwhile, the attorney fees are ticking, 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 ticking. Yeah, so that would be my suggestion in terms of how to try to get some semblance of control over attorney fees, which can take over a conservatorship.
Thank you. I really love that idea. That's been a pet peeve of mine too. And I think you're right. It creates a leverage situation. And I've been involved with a couple where there was no notice to the conservatee, right? And the person walks right in, gets it same day, and then everyone, the conservatee in particular, is then fighting from a negative position. Is that something that we could take up with the judges? I know that they have to be aware of it as an issue, and it's the consequences also that their docket gets overwhelmed by cases that don't even belong there. What's our mechanism these days for talking to the judges about these kinds of procedural issues?
I think it's through our probate leadership. So generally the Contra Costa probate bar sits down with our judges and says, here are the issues that are coming up.
Do we have a meeting like that scheduled anytime soon?
I think
I'd
in
ask
July,
Kathryn, but she's on vacation.
okay.
And
I'm on the board, and I think our next meeting is in July.
Okay.
Kathy, I also wanted to share with everyone, I attended a really interesting EBTEL CLE, and the entire presentation was on the role of the court-appointed attorney in conservatorships. And EBTEL, this group took a very hard position that under no circumstances should you be doing anything but advocating for what your client tells you to advocate for. And if there is any doubt about whether your client can participate in his or her advocacy, rather than sharing that opinion, you should essentially say, I don't have a client, I can't represent the client. So, you've got a client who can't communicate. I have one of these right now, who's in a coma and they can't participate in their defense. You should report to the court. You have no available client, and the court should appoint a guardian ad litem. And these two practitioners said, anyone that does otherwise is at risk for ethics complaint. So they don't see a black and white situation at all. They went through a whole, legal analysis of the rules, the ethics rules, and even common law. And so I've really had to rethink, because I was sort of with you, Lara. I thought, in the interest of justice, can you wink, wink, indicate to the judge what you think should happen here? But this panel made me rethink that. There was also a Trust and Estates Quarterly article that addressed that specific issue.
Yeah. Judge Sugiyama in a case wrote I think it was Julie Woods, really, but she wrote like a 78-page opinion on that very issue.
And what was the outcome? What was her conclusion?
I don't care what that quarterly article said. It means nothing. There's only 2 states in the entire country that have that opinion, that the court-appointed counsel should advocate for whatever the conservatee wants, regardless. If you want to go play on the freeway, my client's got the right to go play on the freeway, Judge. Let her go play on the freeway. Judge Sugiyama's absolute, Julie Wood, 100% against it.
Oh, that's interesting. And these practitioners even said, if the judge turns to you and say, okay, Ms. Lankford, I appoint you as guardian ad litem, you have to decline. No, I can't do that. Sorry, Your Honor.
That seems practically crazy to me, because the whole point of the appointment is that this person can't retain an attorney and needs somebody to, I get that they should be advocating, but the idea that they actually need 2 people to represent them, I don't know, that rationale doesn't make any sense to me. And I've read both of the Sugiyama opinion and the quarterly thing, and I've heard the guardian ad litem position before, but from a practical, how do we best serve this population, that doesn't make sense to me.
I'm with you, Kathy. I mean, I do think it's kind of bullshit. And I honestly don't think, other than Alameda County really follows that. And, Senior Legal Services, Kristen Boney and Kirsten Howe, they stick by that very close, but they won't, you can just tell by their delivery, and the judges know what they think. They'll say, my client does not want a conservatorship. And that's all they'll say. And in Solano County, where it's the public defender representing the conservatees, they will make it very clear to other counsel and to the court what their client wants, but they generally don't go hard when it's obvious that their client is completely demented and going in the wrong direction. I feel like the Alameda thing is kind of bullshit. Like, nobody really should practice that way.
I'd like to jump in here. Can you guys hear me?
Yes.
Okay, so I have studied this very carefully. I was the subject of that 78-page order that Judge Sugiyama signed, or yes, that's right, it was. And he had 68 footnotes on it also. And basically, I read that article and I also went to the EBTEL talk. And there's one thing they completely never mention once ever. And there's the probate codes 1470 and 1470.1, right? And basically, when I get the appointment to represent a conservatee, it's under those two probate code sections, and it's also for their interest and their best interest. And so I think that they have an opinion, and the main structure of their opinion is the California Supreme Court had a chance to make a decision and they didn't, and therefore it automatically means that this is what they were trying to say. Of course, it doesn't say that. So anyway, I think that if you have a client who's being unduly influenced or has an abuser basically taking all of their money, and they say, because they don't really understand that their abuser's taking all their money, and they say, oh yeah, whatever's okay, I don't care. I'm not going to just stand there and say, oh yeah, like Matt said, if you want to go play on the freeway, go ahead, have a good time. It's sort of like that. They can take all your money and leave you homeless on the street. It's no problem, because my job is to just tell the judge what you want me to tell them. So anyway, I just wanted to mention that.
One of the things that I've done when confronted with that situation where the conservatee doesn't know, because of dementia, the reality around them, either because of a abuser or they don't even really understand what a conservatorship is. They know they don't want one though.
Yes.
Yeah.
Is I ask whether or not they're okay with the status quo. Like, do they like where they're living? Do they, well, do they like where they're living? Do they think that their needs are being met? And get a little bit of context, because that gives me more that I can report on. But I am always troubled with the duality of, you're supposed to be advocating for what's in your client's best interest, and you're supposed to be advocating for what they want. And I'm with you, David. I can't in my soul say, go ahead and play in the freeway. But I have to find a way to report what my client's position is.
I always just say it. I just say it in my report. I mean, I wrote a number of reports in that case that are filed, public documents. And, these two people that wrote that article and gave the EBTEL talk would say I breached my ethics as an attorney. But I would say under my court order in the probate code, I was following my order from the judge in the probate code. And I definitely always said what my client wanted in every hearing, in every report. And then I just gave all other facts that were relevant also. I never breached a confidentiality that a client gave me. I never said something that they told me in confidence. However, I don't think I spent more than 10 minutes with them in like 2 years without their abuser sitting next to them. So nothing was confidential. And the abuser was always doing all the talking. They wouldn't let the conservatee talk.
Mm-hmm.
So, it's kind of interesting, huh?
Anybody else have insight?
Yeah, sometimes it's very interesting when you're talking to the conservatee as court-appointed counsel, and the abusers are so bad at what they're doing, because you can hear them like they're talking to you on the phone, telling their person what to say.
Mm-hmm.
It's like, go away, person. Let me talk to my client.
I've been in court with Judge Sugiyama, and the abuser is sitting there telling the conservatee what to say in front of Judge Sugiyama. He says, I'm sitting here listening.
Yes. No, actually, I got to share one story with you, which was just simply beautiful. So conservatorship over mom's sitting there. I got my client, and then we have the other client. Mom is like 94 years old, can barely speak. But the one alleged abuser says, "Mom, you want to talk to the judge, don't you?" "Yeah." "Well, tell him what you want to say." Good morning. And then that was about all. But then she actually hits her mother. Says, "Mom, tell him you want me to be in charge." And Judge Yama, wrote some notes and commented that I observe everything that goes on in my courtroom. So good luck at your mediation. We'll see you back soon. But I could not believe that the daughter actually hit the mother and screamed at her in court in front of the judge.
So let me open this up to other issues. What other ethics and civility issues do people see out there in the courtroom or dealing with other attorneys out in the community that you are concerned with? Or how about a success story? I would love a success story.
Well, I could talk, but I don't have a success story.
Okay.
Well, what I'm finding is that attorneys are personally attacking another attorney, their integrity, their honesty, maybe in open court, in court filed documents, and questioning their motives. And I find that very discouraging. There was one case I'm aware of where there were like 3 or 4 attorneys, and one attorney was objecting based on his client's best interest. And another attorney just kept criticizing him and saying, "Well, he's just a lone wolf, like, how dare you not go along with the pack?" But of course, we each have our own client's interest to represent. So even if there's 3 or 4 attorneys and one's objecting, they're doing it based on their interest, representing their client. So to be singled out and said, "Well, you're not going along," so like it's a derogatory thing, you're not going along. And I find that discouraging.
Okay, to play devil's advocate though, I've been in cases like that too, and the person who's not going along is really being obstructionist. And I don't know.
You can do it professionally. See, attacking someone's personality, their motive, their honesty is not what we're talking about here. I know many attorneys that are highly professional, and you can do it in a very professional way.
I had a court-appointed attorney, his name is Randolph Stein, I don't have a problem saying his name, who I offered to update. He called me at the last minute. We were going to have the hearing in a few days. And he called me, he was just appointed and, wanted to get some information on the case. So I offered to talk to him. He says, "I don't want to talk to you, just send me the file." So I was like, there's a lot of things going on. The file's not going to fully reflect the issues in this case. And it's really important. And he just, on his first report to the court, he just attacked me. The whole thing was an attack on me. It was the most outrageous thing I saw. And the judge didn't do a damn thing about it, and wasted a lot of time and money of my clients because of this. And then this Stein got involved. There was friction between the petitioner and the family. And he sort of stoked the flames for that and made this thing worse than it already was. I filed a complaint with, I forgot, Green, I think it was. Nothing happened, and he's still on the panel, I'm sure. But that happens. I had another case in San Francisco. I mean, the guy didn't attack me personally, but he knew that the daughter was abusing the mother financially. And he was on board with me, but then when he talked to the mother, and I understand he has to represent her zealously, but he wasn't looking out for her best interest. So my client gave up, and now she's probably going to lose all her money. And that's the end result. It's kind of sad. It's a frustrating area to practice it. But you just try to do the best you can.
Kathy, I feel like one of our cases together was a bright spot. And I think it was, we had really strong emotions on both sides. And it brought up all the Dad loves you more than me when we were 13. It brought up all the family history. And I think we did a good job of, yes, we advocated for our clients, but behind closed doors, we also encouraged our clients to do what was best for dad. And we did end up mediating, I think, fairly early.
Mhm.
And, you know, I don't know if we saved that sisterhood, that I'm not sure that sisterhood was ever repairable, but you know, we created, I think, a great end of life environment for dad. And again, I think we did a lot of that behind closed doors, while also at, you know, and sometimes you can't control your client. I think, you know, most of the time we can though. And if you can help your client wade through that extreme emotion, and as you said, Kathy, refocus them on what is best for dad or the conservatee, that in the end, you know, that you've done a service to that family. And so I feel that that case that we had, I don't know if you remember it, it ended up going, you know, blowing into a trust admin matter as well. But I was really proud of the way we handled that. And I don't remember the bill being outrageous.
No, it wasn't.
We helped this family. We did so efficiently, and we did it through great advocacy on behalf of our clients, but a lot of behind the doors refocusing the client on what was important.
So in doing the research for the ethics rules on this, there's been changes at the state bar level. In 2018, they implemented a bunch of changes. One of the things is taking the word zealous out of zealous advocacy, because that's not the goal these days, I guess. Zealousness has been the rationale for why you can do some of the things that people do. But really the goal should be more do what's in the best interest of your client, not just what your clients want with any technique possible. I thought that was really interesting that they felt the need to take that word out, because it's tossed around all the time as well. Everybody needs to be advocating zealously for their client. No, actually, it's not. That's not true. Effectively, yes. Anybody else have anything to add? We've got just a couple more minutes and then we're done.
Before that, I just wanted to say, I'm just going to run the last poll. So if people need to leave, they can. You guys can keep talking for a while if you want. So, I just wanted to get that out of the way. So if people need to go, they have their hour. And okay. Nope, a couple more people. It's the two of us. Okay.
Any other questions or comments or suggestions? Well, I personally would love a continuing conversation over these issues, and I appreciate everybody's involvement with this conversation. I think that if there's a takeaway of one action item we can do, it's bringing the temporary conservatorship issue to the court. I think that's a great first step if we can somehow implement a change around that. If anybody else has additional ideas of things that we should be bringing to the court's attention, feel free to email me or anyone. Well, those are the two new things. If there's any other comments that people have or questions, please don't hesitate to contact me. I'd like to see this as an ongoing conversation, like I said.
I think Matt mentioned that he's on the estate planning board, and you guys have a July meeting coming up with the court.
Yes.
So if there's anything, it would be to Matt or Kathryn, right?
Right.
Kathryn Korn. And if you need their email addresses or their contact information, you get in touch with me, or it's on the CCCBA website under the estate planning and probate section page. And if there's other people on there, you might feel more comfortable contacting that are on the board, that's there too. But that would be a great place to start with that particular issue.
Great. Well, thank you, everyone.
Good job.
Thank you,
Thank you,
Kathryn, for
Kathryn.
doing this.
Well, let's keep the conversation going. I think it's a really productive one.
Okay,
Thank you.
thank you,
All right.
everybody.
Thank you.
Good job, Matt. Thanks for helping with the.
You're welcome. Take care.